One of the economic strengths of Nigeria's gross domestic income is the oil and gas sector. In today's spectacle, your favorite TVM program, we shall explicitly be looking at the gas supply processing agreement contract entered in 2005 between the federal government of Nigeria and a British firm known as Process and Industrial Development. Precisely, the recent UK court order that fined Nigeria a contract breach of $9.6 billion as compensation to the P&ID, that is a Process and Industrial Development Company. I am your host, Daniel Atai, and with me in the studio, of course, there is a colleague and an in-house analyst by the name Victor Tehemba. He's a social commentator and a writer. And probably we'll still be joined by an expert, an oil and gas expert, and who have masters in law from the University of Dundee, talking about Barrister Madaki, is on his way. However, before I take on Victor, let's look critically into the subject. Let's look at the background of the contract. The contract is known as the Gas Supply Processing Agreement, which was entered into on behalf of the federal government by the Ministry of Petroleum Resources, signed on January 11, 2010, between the ministry and the company. It entails that the federal government is to supply this UK firm for 400 million metric standard cubic feet per day of wet gas for a period of 20 years. The company was to process the wet gas into lean gas for gas-powered electricity generation plant fueling. The firm is to pay a counterpart of 85% of the lean gas proceeds from the process and be compensated through the byproducts, such as butane, in order to sell in the international market. Nigeria was to benefit from the sale of the byproduct through 10% share in the British firm. The supply of the wet gas was to take place in two phases. The government was to make available 150 cubic meter of fuel per day during or before the last quarter of 2011, while the second phase, the remaining 250 metric ton must be supplied on or before the third quarters of 2012. The Process and Industrial Development Limited was to build 2 or more plants for the processing of the wet gas into lean gas at no cost to the government, since it would be compensated from the proceeds, talking about the proceeds of the byproduct. However, it was alleged that the government failed to build a pipeline to supply gas to the company. The company also failed to construct the plant for processing the plant. So on August 22nd, 2012, the British firm filed an arbitration in the UK court. It wrote the federal government on March 20th of 2013, accusing it of repudiating the contract it entered with the company. The government alleged that the agreement was on various grounds invalid or subsequently frustrated, varied or discharged by force majeure. And a panel of arbitration ruled that Nigeria was liable for the failure of the contract and should pay the British firm a sum of $6.597 billion as a profit that would have, amassed to the company for the 20 years tenure of the contract. It also ruled that the company should be paid 7% interest until the award was settled. And this has increased to 9.6 billion naira judgment debt, as the firm had recently sought and secured from the British High Court the conversion of the arbitration decision into a court judgment. I want you to note that not much can be learned or learned anywhere about this very company except its case against Nigeria. It appears, therefore, that the company is a portfolio firm incorporated in 2006 to secure the contract with Nigeria. However, its founders named Brendan Cahill and Michael Quinn had a 30-year track record of planning and delivering projects in Nigeria, the company claimed. These include projects that had real and measurable positive impacts on the Nigerian economy and people, the company also added. The question now is, this very unknown company entered agreement under President Obasanjo's regime down to Yaradua to build a gas plant that would process and supply lean gas to the international market. While it is a portfolio firm, as of the time, the contractors have been known to have been doing business with Nigeria for over 3 decades, talking about Brendan Cahill and Michael Quinn. Why was a contract that seems beneficial to Nigeria be overlooked from Yaradua's regime, Goodluck's regime, and resurfaced in the regime of President Muhammad Buhari? Have your take concurrently with our guest analysts via the telephone numbers that will be displayed on your screen. For the sake of the vision impaired viewers, of course, the numbers are 081-3701-5949 or 070-5432-7616, and give us your quota. What do you think about this contract? Mr. Victor, 3 regimes have passed, and suddenly the firm, the UK firm, is an Irish firm and registered in the United Kingdom.
Yes.
And they have filed a suit claiming a compensation. Of course, the court have given them a verdict of 9.6 billion. What do you think the Nigerian government should do now? Are we to negotiate or to?
You see, what the Nigerian government needs to do is what the Attorney General yesterday said that the government is going to do, and that is what I think that they should do. Appeal that decision, argue their case further. And then maybe before I go further, I would just need to get clarity, because from my knowledge of the case, I know that the contract was signed in 2010. On the 11th of January 2010.
Yes.
That was when it was signed under the Yaradua regime.
Yes.
And when we look at the time,
but it was introduced since 2005.
No, because if you remember from your introduction when you were reading, you found out that the company was registered in 2006, and it's very clear to even the blind and to the dumb that if the company was registered in 2006, and like you say, it was a little known company from nowhere, so it was registered for the sole purpose,
and it was even for
just for the sole purpose of getting this thing. So you could find that these guys, like you said, they'll be in Nigeria, be doing other things, supplying HIV kits, building and repairing military tanks, doing all sort of contracts.
So is a positive firm, is a non-firm that could give us
what was supposed to be. And when you look at the company for the fact that they are not, even from the company's website, they have sketchy things that they don't have really so much to do with the oil and gas industry. But here they are being given a contract to build that kind of
the gas plants that will supply them lean gas.
Yes, and all of that. So in all of this,
and they said at no cost at all to the Nigerian government.
Yes, to the fact, no, not necessarily that there will be no cost, because remember they said the government is supposed to build a pipeline for them.
Yes.
So that is an expense that the government will have to undertake. You understand? And the government had 10% stake in it, and they are going to be compensated with 40% of what they get to process, then they sell off another.
Okay, what they gain is the byproduct.
The byproduct of
and they are the ones to also build the gas plant in Nigeria here.
Why the government build the pipeline that distributes these byproducts that they get, or to even supply the gas to the gas plants.
So how come did concurrently, like we said, we'll be picking calls, but then you can go ahead. How come did is it an oversight on the part of the administration of Yaradua?
So if you do now, let me just go back now. Within that period where this agreement was being negotiated and being signed, that was the time where the president was incapacitated, the late Yaradua.
Okay.
Now, this contract wasn't even signed in Nigeria. It was signed when the president was in Saudi Arabia.
Okay.
To begin with. So at that time, we had somebody who I would rather call a mischievous Attorney General of the Federation, somebody who, in my own record's opinion, is the worst Attorney General in Nigeria that we've ever had, and that was Michael Ondunaka.
Yeah.
And he was part of the alleged cabal that were putting this. And that was at the period he came out to say the president has the powers to rule from anywhere. That is in trying to defend the decision of the president not to hand over power to his deputy, which we have seen the current president do time and time whenever he's traveling now, which is supposed to be the normal situation.
And the deputy then was Goodluck Jonathan.
So Goodluck Jonathan wasn't even privy to this agreement.
That was why he said he refused to sign it.
To move ahead
with the contract.
With the contract. Now, in all of this, I have an issue that if you are going to award damages, you award damages of 6.9 billion naira at first, and then we say it is for the 20 years period that they would have gotten. Now, this contract was signed in 2010. Now, 20 years period is supposed to get to 2020. Then you award
2030.
2030?
Yeah.
Yes, 2030, sorry. So it's supposed to be in 2030. Then they bring a case, you award that for the 20 years, they're going to make a profit. Now, how did they come? Market forces are not static, they are dynamic, they change. So there's no guarantee that they would have made that much or they would have made higher. But we are putting it, okay, let's assume the court has taken that decision. Now, when you say 20...
Yeah, the court decision is based on the current conversion of money naira to
current
dollars.
Market
and even if current market forex exchange,
going forward to
and even what they said is that if you convert the money, the 9.6 billion they are talking about now is about 2.7.
It's 3.2 trillion naira, which can actually finance our national budget in a year.
More than a year, sir.
So
to surplus.
But going forward to where I stopped. Now, when you give a judgment of 20 or for 20 years that their profit is going to be, but the judgment is their profit is supposed to be made for 20 years, and then you are saying that until the government pays, the government is going to incur a 7% interest rate.
Yeah.
The 20 years hasn't even come. And then we are paying interest ahead.
So that is why is it not schemish?
So then I'm saying,
not schemish on the side of the contractors?
The right thing the government ought to do is what the Attorney General said yesterday they will do, that they are going to contest, they are going to appeal that decision. And I think they will go. And I think if they put up a strong team that is going to present their case quite okay, then. But the truth of the matter is this: let us not just agree with it. There was a breach of contract on the part of Nigerian government. We can agree to that. Even the Nigerian lawyer that was supposed to represent the interests of Nigeria, I think in a way during the first judgment of granting 6.9 billion naira judgment against Nigeria, I think he was of opinion that yes, Nigeria had breached, but it can't be that way. Yes.
All right. Thank you, Mr. Victor. And shortly after this timeout, we'll introduce our guest analyst that is already on his way, in the studio, and to throw more light on the energy, oil and gas energy law situation that we found ourselves as regards this contract now. You are most welcome, Mr. Victor.
All right, thank you.
Thank you for that wonderful take. After this timeout, we'll be with you. Welcome back. And of course, our guest analyst and energy law expert, talking about Mr. Madaki Ame Esquire have joined us in the studio to look into the very topic of discussion today. We're talking about the 9.6 billion Naira UK fine against Nigeria Petroleum Resources Company. Mr. Madaki, you're welcome, sir.
Thank you very much, Dan. Always a pleasure.
Thank you. You are an expert in this field. And of course, you studied here in Scotland and in the University of Dundee. You have your master's in energy law. This contract between Nigeria and this process industrial development, what implications are there in it against Nigeria?
Well, thank you very much, Dan. Yeah. As always, it's a pleasure to be with you.
Thank you, sir.
Now, the situation we find ourselves in with the award, that was made in the arbitration proceedings and then confirmed by the High Court of Justice in England, specifically by Justice Butcher.
Okay.
About a week ago.
Yes, a week ago.
Is such that, it should, first of all, jolt us into knowing that we have a financial liability to face, which, if we don't handle carefully, can actually lead to very dire consequences, because $9.6 billion is 20% of the national budget of $24 billion. So it's a lot of money.
Yes.
And
it could cause economic havoc.
In fact, it could cause dire economic havoc for us. It's actually more than 20%, about 40% of the budget.
Okay.
So but it also should teach us a lesson that, you see, international commitments are not similar to local commitments. It's actually a good idea to comply with all commitments that you are faced with. But you see, where you can tinker with your national commitment, because the courts and the court execution process within your jurisdiction are largely within your control.
Yes.
But when you go into international business and you're doing business with companies on the international scene, capacity to comply to the latter, as far as contracts are concerned, it's extremely important.
Yeah.
So I hope that we learn a lesson from this, because we're a very sloppy nation. Nothing is ever.
We cannot appeal the case.
Even if we appeal, I do not think that we are going to be able to win. I have assessed it as a lawyer. You get the point. Our chances on appeal are extremely slim, because if you look at the history of this matter, it's been lingering for quite some time. This contract was entered into, when Ridwan Lukman was Minister of Petroleum.
Okay.
And then the execution or non-execution of it has been passing from one administration to the other and all of that. But the last story around it is the fact that sometime in 2015, just when President Jonathan was about to hand over power to President Buhari, that was when the judgment crystallized. And at that time, the figures were not even as high as they are now.
It was 6.8.
Yes, it was. And it was, President Jonathan went into negotiations with them, and they agreed to take $850 million in full and final settlement originally. And when the thing was brought to President Jonathan for approval, he still felt that the figure was high, and he asked them to go and renegotiate. And they went and renegotiated, and they accepted that they would take $600 million in full and final settlement. But he felt, because he was in the twilight of his administration, that it would not be a responsible thing to do, paying that kind of bulk money at the twilight of his administration.
But I thought the firm said at no cost to Nigeria.
No. Let's make this point. Let me try to establish this point.
Okay.
So, in the handing over notes of President Jonathan to President Buhari, he included it there that there was this liability of $600 million, which had fallen due, and that it will require to be paid to enable Nigeria, move on, from that contract situation. But when the new government came in 2015, rather than follow through the process and see through with the payment, they called the entire process to question and wanted to renegotiate or relitigate the entire process.
Okay.
And they didn't do it in a smart manner. So that made the claimants to go back to court. And when they got back to court, the court reinstated the entire award and awarded interest, and loss of income for the entire period of the duration of the contract for 20 years. And that's what took everything to $9.6 billion, which is the current judgment, the current award, which has now been enforced and, has been ordered for enforcement, by the High Court of Justice in England. So what that means is that immediately the claimants are entitled as of right to seize any Nigerian asset they see anywhere.
Because they are even threatening to seize our ships, our naval vessels supplying oil and stuff like that, and that. But
it is their right.
Have they commenced, the supply of the gas?
The stage we are now, is not the stage where we will discuss whether the contract has been executed or not. They have been able to prove their claim before the arbitral panel. But don't forget that before in every arbitration, the claimants are entitled to be represented. The respondents are entitled to be represented. Okay. And all the legal arguments for and against are supposed to be put before the panel. And the panel will now come up with a judgment, with an award about whether the claimants are entitled to or the defendants. So we are not even at this stage able to argue the justice of the matter anymore. That would be completely an academic exercise.
Okay, but
what we should be focusing on now is damage control.
Okay. The damage control from the perspective of the claimants, talking about Brendan Cahill and Michael Quinn. Don't you see them as portfolio investors?
It doesn't matter. The truth of the matter is that they came here, they identified an opportunity, they convened the government to award the contract to them and sign it. So they have an executed contract to get some work done.
Between Obasanjo and them and Yaradua, who signed that agreement?
I told you that it was signed during the regime of President Obasanjo when Riwanu Lukman was the Minister of Petroleum. Yes. You get the point. Yes. But I also don't want us to get into this messy blame game culture. You get the point. Yes. Nigerians are very fast to blame. Who do we blame? Okay, how can we exhume somebody who has died, and blame him as much as possible? If you ask me to blame anybody right now, the person I would blame is the Attorney General of the Federation when they refused to comply with the settlement.
That was Michael Andok.
No. It will be the Attorney General of the Federation, which is the current Attorney General who has just been sworn in, Malami. Why I would blame Malami is because he is the inaugural Minister of Justice in this current administration. Yeah. It was his duty to properly advise President Buhari on the implications of not following through with the handing over notes of President Jonathan as far as this award was concerned. Okay. Because as a lawyer who is up and doing, the first thing you do in this kind of situation is to actually look at the legal exposure and compare the exposure with what you have settled for. And so we're not at this point, all the efforts at arguing about whether it is right or wrong, have they done the work, have they not done the work, is completely academic.
Okay,
the stage we are now is not the stage where we can relitigate or re-argue the matter. Okay. But what we must focus on now is how to save this country from having its assets to the tune of $9.6 billion seized internationally to satisfy this judgment. And there are many ways they can do it. They can attach our foreign reserves through Ghana proceedings. And that's the simplest way, actually. You go, you get an order against the bank that holds the money that belongs to the federal government internationally. And the court order in the Ghana proceeding, what it does is that it directs the bank that is holding the money to pay the money directly to them.
I understand, Mr. Madaki.
Yes.
Don't you think that what you are saying now is like fueling the crisis against the federal government?
It is not.
Don't you see it as an exploitation on the part of the claimants?
What do you want to happen right now? You have listen.
No, what I'm saying is that you have 20 years contractual agreement to follow. Mm-hmm. And then, of course, you have not even spent 10 years out of it. And then here comes the claim.
No,
Don't you think the damage control can still,
Dan, I think you are getting it entirely wrong.
Okay. Okay.
And why you are getting it entirely wrong is that the duration of the contract was supposed to be 20 years from commissioning of the project.
Okay.
You get the point I'm making?
Yes.
Now, but if the project could not be executed because some of the conditions precedent to their capacity to get things done were not done. For instance, the major ground on which they succeeded in court was because the federal government was supposed to lay a pipeline, a non-associated gas pipeline from the nearest oil gas facility to where the facility was supposed to be located in Cross River State.
Yes.
That pipeline was never laid. So the argument before the arbitral panel was that because the pipeline was not laid, there was no way they could have constructed the facility.
Have the investors given their 85% counterpart funding? They said they will give to the Nigerian government.
They were the ones who were meant to execute the project.
Okay.
You get the point. So were they supposed to give money to the federal government to enable them to execute the project? They were not.
Okay.
They were awarded the contract to get the job done.
Okay.
And they had this spend down. There were obligations on both sides. Their argument before the arbitral panel was that those obligations that fell on the part of the federal government to comply with, which was supposed to enable them execute their own part of the project, were frustrated consistently, and that even when they tried to bring things back on stream, that every step of the way they met with frustrations until they were now completely unable to execute. And then being unable to execute, they have been put to financial loss, for which the law always provides a remedy.
Okay.
So let's not get into any patriotic argument about whether, it was right or wrong or whatever. All right. There is an agreement. There is a breach. There is a remedy. And the court, in their infinite wisdom, has awarded that remedy at an arbitration panel where the country had an ample opportunity to be represented and to present their case. So if we lost it, and then we did not take immediate and smart moves to mitigate our losses, and we are coming to cry after the head is off, then this cry, honestly, we are just weeping blood for nothing. At the end of the day, we will still have to pay.
So what do you advise the federal government?
What I advise the federal government to do from the release I saw from the company, I read it from the company, they appear amenable to have a conversation around how this will be done.
Okay.
That conversation needs to be done in a non-confrontational manner.
Okay.
Because if they go and they continue with their argument about being a sovereign nation and you cannot execute against them, they are deceiving themselves, because there are loads and loads of authority to the effect that when a sovereign nation, breaches the terms of its contract, you can execute against it like any other defendant. So at the end of the day, if the government wants to do damage control with its audience, the local population, so that people will not feel apprehensive that there's a big challenge coming, I can understand. They can use their propaganda machinery to do that. But that still does not mean that we cannot be taken for lunch.
Okay, thank you, Barrister Madaki, for that wonderful take. And I believe the government is listening to your advice. And we pray that they will come to terms and resolve this issue so that we don't have this kind of economic havoc that is pending. That is where Spectacle will stop today. And thanks very much for watching. Of course, we're unable to take your calls and your text messages because of a time factor. However, Spectacle is open for sponsorship. And of course, you can reach us always via the telephone numbers displayed on your screen. Once again, I'm your host, Daniel Atai, and thanks for watching.